the Rowan Consulting Shed Talks. These are our discussion series on subjects aimed to inform and equip business owners with helpful advice on managing and engaging teams. So this series, as usual, supports our programme of leading the business and teams, all especially very, very relevant right now during the current climate as we continue to see ongoing changes in terms of the business. So let's dive in with this subject. We've had a few questions in from people and we'll aim to answer those as we go through. If we don't get to your question, please don't worry, we'll be sure to message you back as soon as we finish the session. So today's subject, quite a wide subject and one which I think is quite relevant at the moment. We're talking today about understanding the holiday changes to part-year workers and what this will mean to your business and your industry in whatever form you may be in. I'm going to introduce our speakers for today, one of which is a returner to the shed and one who's new. So let me introduce you to Annie Hill, Legal Exec, and Sean McDonough, who is returning visitor, Managing Partner and Employment Law Specialist at Moses Druitt. Welcome to the shed, guys. Nice to see you.
Hello.
Hi, Karen. Nice to see you too.
So for those of you who don't know Moses Druitt, tell us a little bit about you and the business. What can we expect?
So Annie and I work in the employment team at Moses Druitt. We're a broad-based employment team doing a whole range of disputes and sort of non-contentious type work. The firm has 3 offices, Bath, Wells and Sherborne. And we do legal services and financial planning services to a whole range of different clients.
Thank you very much. Like I said, nice to see you back again.
Yes, nice to be back. Last time I was in your shed, I was in my own shed.
You were in your own shed. You were.
I don't have that shed anymore, so sadly.
No shed no more.
No shed no more. New house, no shed. So
I'm gonna have to revive. You're gonna have to get a new shed now.
Just for these talks.
Yeah. Well, I said, welcome back again. Now, so this subject is very large and seems to be there seems to be a lot of opinion, I think, in terms of this subject. Part-year workers, it seems to be on the agenda, off the agenda. It's like the government are in, then the government are out, and so I think the general feeling is from sort of our clients' feedback is it broadly sort of falls into sort of like 3 topics, and that's what I want to discuss with you today. So let's start with the sort of first one. What has happened in terms of this piece of legislation? What's happened and what does it actually mean to my business right now?
So the case itself involved Mrs. Brazel, who was a music teacher for the Harbour Trust, and she was engaged on a 0 hours permanent contract. So she was working different terms in the year, and she was paid per term for her holiday, accrued holiday. They calculated her holiday pay using the 12.07% method that ACAS have historically used in their guidance, which is effectively a pro rata of a full-time person's pay. And what she said was that she doesn't think, well, what her lawyer said is that that didn't follow the actual legislation. So the case looked at the wording of the legislation and determined that actually that's true. The 12.07% rule didn't necessarily follow that legislation. So what they suggested was that a 52-week reference period should be used instead. So rather than prorating it based on a full time, you're actually working it out based on what was worked in a 52-week reference period and a weekly pay based on those 52 weeks. If there are any weeks that aren't worked or no pay is given, then you discount those weeks. So you've got 52 weeks, and let's keep it simple, say there's 2 weeks where there's no pay. You don't count those 2 weeks and you go back 54 weeks. And that's how you work out your average for a week's pay, which is where the holiday pay entitlement comes from, but following this case.
Right.
What that means is a lot of people that have been using the 12.07% and a lot of people that use HR resources that use and services that use the 12.07% technically might be incorrect.
Okay.
Which in itself is kind of staggering, isn't it? You
Yeah.
think an entire system, an entire industry of HR resourcing software and all the rest of it has been built on ACAS guidance, which doesn't reflect the legislation.
Yeah.
It's kind of crazy.
Yeah.
Interestingly, in the case that Anisha's been talking about, the actual amount of disputed holiday was a huge £700.
Mm-hmm.
Right.
So, which has been was referenced in the decision as being high in the circumstances, as being on the higher side of the amounts that will end up being in dispute.
Mm-hmm.
So there's a huge amount of turmoil and a government consultation process, which Sally will touch on in a second, for what we think are going to be relatively modest sums of money. Brazel was employed for 4 years.
Mm-hmm.
So that's 700 quid after 4 years of employment.
Yeah.
So
Okay.
just to give you a sense of the sort of quantum of claims, they're going to be small.
Yeah. Yeah. And I think we've actually got a question around that in a minute, because I think that's one of the things, isn't it, is that there is a lot of talk about it, but contextually, what actually does it mean?
Yeah.
And what it seems to suggest is actually there's a bigger systems and process change than what there actually would be in terms of, you know, what we're looking at, like you said, in terms of, you know, likely sort of fees and sums that will be payable as a result of going back as far as you need to go back for.
Yeah.
Interesting. Very interesting. Okay. So in terms of then the next sort of set of questions were around the action that companies or that companies will need to take now. So from what I understand, the government is in a position of saying they're going to go back and revisit it. They don't necessarily agree that it should come in as a result of the findings. So where we are now, because we know that things change on a regular basis, what would you suggest that companies need to do now?
I think you need to take a look at what their part-year workers have been paid holiday entitlement wise.
Mm-hmm.
We would recommend going back 2 years. If they can, because that's the sort of the cap for what the risk is, what the engaged worker employee will be looking to bring if they do is an unlawful deduction of wages claim.
Mm-hmm.
And that can go back 2 years. So that's where that 2 year point is coming from.
Okay. Can you give me sorry, just going back slightly, the definition of the part-year workers? Let's just be clear on what that part-year worker is. Is there a definition?
No.
Or is it, no, there isn't. Oh, okay.
Part-year worker, I don't believe, is a term that appears in the legislation. So that's just a generic term that describes somebody who isn't permanent or who works irregular working hours.
Right. So if somebody
in my head, it would be a 0 hours worker or a term time worker or something like that.
Okay.
Seasonal, term time, 0 hours, somebody who's on annualized hours, those types of contracts.
Yeah. Okay. So just to be clear then, we're actually not talking about people who are, because this is some of the perception we've got in the industry is that it's part-time. We're not talking part-time here. What we're talking is 0 hours, term time, or annualized hours types of contracts. That's where we're looking at. So Annie, when you said go back and check your part-year workers, we're looking specifically for those people who are on those types of contracts.
Yeah.
Yeah.
Great. Brilliant.
The part-time employees, part-time workers will continue to accrue holiday on a pro rata basis as they have done historically. So those types of contracts haven't typically, well, in our experience, those types of contracts won't typically have had the 12.07% thing applied to them.
Mm-hmm.
It's going to be pro-rating it based on their actual hours of work and actual pay, whereas the 0 hours contracts would have had that 12.07%. So to make it even more relevant for your clients, it affects those clients who have applied that ratio.
Mm-hmm. And if their ratio is actually based on, because you reference assistants, that we think there's a bigger issue in terms of the HR platforms and systems that people are using. So have we seen anything from them in terms of, changes that they're likely to be making, or are we talking here that belt and braces, we should be advising clients that actually you need to be looking at your systems and checking with your system providers that they're making those changes now?
Yeah, they need to be, because at the end of the day, in the event, and being blunt and a lawyer about it, in the event of a dispute, regardless of the value of that dispute, the tribunal will look at the legislation, not your HR system. So the employer's responsibility is to comply with employment legislation. So they do need to look at their systems.
Okay. Okay. So third type of question then is, what are we still waiting for in terms of announcements from the governments about what happens next?
So the consultation that's currently ongoing ends at midnight on the 9th of March. And as far as we're aware, what they're looking at the moment is there is a bit of an anomaly in relation to the 52-week reference period, where this don't count weeks when no pay was given. Is skewing the averages in very, very minor cases. So what they're doing is they're looking to determine whether it should be 52 weeks fixed. And if you weren't paid in those 52 weeks, then that still counts. And your average is calculated on that. It's this extra week for weeks not paid, adding that on. That's what they're looking at.
Right.
Okay. There was an example used in the case itself of a term time worker, exam invigilator, who would work 3 or 4 weeks a year and then not work again. And for reasons that neither Annie nor I can work out, that working pattern results in an enhanced entitlement to holiday pay compared with somebody who was working a part-time contract. So on a pro rata basis, the individual who's doing that 3-week block and then not working until next year and doing 3 weeks ends up with a higher hourly holiday entitlement than you would ordinarily. I genuinely can't understand how, but that was the case that was referred to in Brazil. And the court said, well, that's just an anomaly of the legislation, and there's lots of those anomalies in law. It's quite rare, so let's not worry about it, which
two lines in the judgment, I think it's
is a bit unsatisfactory. So that's one of the things that we're hoping will be resolved, and let's hope sense prevails and we just get a 52-week reference period, whether you've earned or not, and it's just nice and straightforward. So that would be the ideal outcome, wouldn't it? So
yeah, because I think, just, from some of our clients, we've got, education, we've got, health and social care, where those annualized hours and those term times do come in. And I think the biggest concern of that is having to go back. So, the details that you gave us about go back 2 years, and, that's all really, really sort of helpful advice, because I think the perception is that you were going back for a longer period of time, and this could potentially go back over years, and it could be, resulting in thousands. And, there's a very real, there's a very, very real feeling that we're going to be back to some of those other bigger pieces of legislation that we had 3, 4, 5 years ago, where it was a massive change. Shared parental leave, maybe not discuss that one, but again, huge amount of piece of legislation, the amount of work that HR departments put into it, and then actually, what is the actual outcome? What's the usage? I think we're still working on less than 4%, aren't we? It's like
4%, I'd be staggered. So
So yeah, I think that's the other thing is to make sure that the context of this is, like you were saying, Sean, is that it's relatively sort of it's important sums of money, but it's relatively low sums, and to be able to take a proactive approach to it if you want to. Okay, so Ro, what sort of other questions have we had in? What are people sort of generally asking?
Okay, so a couple of them we've covered off, which is great. One of the questions was around the new potential upcoming changes around flexible working requests, and whether this will have an impact on it.
Yeah, potentially. It might, if if those flexible working requests produce, so I suppose the short answer is yes, it could have an impact, but it's only a materially problematic impact if you have lots of flexible working requests that produce workers who are working for very short periods each year. So if you have somebody who starts working and says, I'd like to work flexibly 1 month a year, which most businesses are going to say no to anyway, then yes, subject to the outcome of the consultation process and the reference period that is agreed, those types of requests could become practically a bit of a pain in the neck. But if it's a flexible working request where somebody says, I want to work 32 hours a week around my childcare, then that just becomes a part-time employee, and that's straightforward. I mean, you would deal with that as you normally have been dealing with those employees anyway.
Okay, great. Another question we've had in, and I think we've sort of covered this, but should we be taking a proactive approach with this with our employees, or should we sit back and wait and see what comes up?
I think the answer to that is driven by the type of workforce you have. If you have a very infrequent, part year type style workforce, then it might be worth having a look at it. So if you pay really high rates of pay for very short periods of work each year, then your liability may end up a bit higher than other businesses who are affected. But if you're talking about part-year workers who are really in practice part-time, because you have somebody who's 0 hours who works hours each week, then it's very unlikely that the change is going to be very different, that the difference in entitlement is going to be particularly worrying. Okay. So you might want to look at those things. You might want to look at it on a risk-based profile to it. So look at the worst ones first and see what the numbers look like and make a decision based on that. But some of the advice we're seeing is, don't worry about it. Let's see what happens. That's not the legal advice, of course. That's what some barristers are saying. They say, look, it's not going to be worth getting into a massive pickle about it yet. Let's wait to see what happens with the consultation, etc., yeah. Because the sums are unlikely to be material. But if you have those higher end salaries for very irregular working patterns, it might be worth trying to get a view on what they're going to be now. Yeah. For those changes, and of course looking at your systems generally to sort of try to prepare for whatever the consultation spits out. So although the consultation finishes in March, there's no timeline published on when any changes will be effective. So it's not going to be, well, they've got, there's so much on the legislative agenda at the moment. It's unlikely to be very quick. Okay.
And then finally, as this progresses, how do our clients find out more about the changes? Obviously, we will update clients as and when, but is there anywhere that you would sort of signpost them to?
Yeah, we'd be very happy to provide ongoing updates. We can do that. If any of your clients want their contracts reviewed, then we can obviously do that. So we can arrange a follow-up shed talk. So yeah, we can do that, and there's gonna be like lots and lots of other resources, ACAS and all the rest of it, but I imagine ACAS are probably feeling a little bit sensitive about the whole thing. So.
Yeah. By the way, your calculation was wrong.
Sort of subtly been updated, but no, nothing really published about it. It's just changed. So.
I wonder why.
Yeah, they just tweak the wording slightly. So.
Interestingly though, Sean, just thinking about it, potentially then, are we likely to see changes to the types of contracts which are being used by companies as a result of this?
Yes, I think there could be, because the trend over the last few years has been towards a much more relaxed form of work. Not only because of the pandemic, but prior to the pandemic, with the deliveries, this world, the Ubers, all that style of working, and it not just being about having your full-time or your part-time job anymore. It's a much more flexible way of working. So. But that clashes in all sorts of ways. One of those ways is holiday entitlement, but that style of working clashes with employment legislation in this country and in the EU, because the legislation is quite fixed and driven towards regular working patterns and that type of thing. So yes, I think we will see employment contracts develop, and there's been consultations previously pre-pandemic about a good way to work and all of that. That hasn't really changed anything yet, but I think it will. But saying that, we've got the retained EU bill coming in, which is meant to be throwing out all that EU legislation. I don't think that will ever happen. So there's quite a lot. There's quite a lot to be thought about when it comes to employment legislation. So I don't think anything's going to change dramatically from a contractual point of view soon, but it could in due course to try to reflect better that flexible style of working. What term I'm thinking about? What's the term in that, the Deliveroo and all those?
I was just sat here thinking the same, and I can't think what they are.
Anyway,
we'll put that one in the notes afterwards. Anyone who wants to add in what that word is we can't think of, then you're welcome to add it in. Yeah, add it in the notes. So really then I think just to sort of bring it all back together then, and in terms of that piece that you were talking about, the potential changes that are coming into the EU reforms stuff that's coming in, one of the things then is to not jump too quickly into trying to change loads of different things when there's a lot of other things that are likely to come in around this as well, in terms of those changes from the EU reforms then.
Yeah, I think so. So because of the potential liability is assuming the potential liability attached to any holiday claim you might suffer as a result of Brazel is going to be quite modest.
Yeah.
Don't overreact, and let's wait for the change. If it was horrific, if it was going to be really chunky, then we might be saying something different. So yes, I think let's probably a wait and see approach is the best one. Sorry, it's just come to me. Gig economy. So gig economy. Yeah, so.
I feel happier now. We know what that is.
As a lawyer, me too. Yeah. So,
okay. So yeah. So general sort of roundup is take a sort of take a commercial business perspective to it. Proactively look at sort of contracts in terms of what you have got on those style of contracts of irregular, 0 hours, term time, and annualized. And then a risk-based approach and how you approach those, and how you want to deal with those sort of moving forward then.
Yes.
Karen, just look at the contract point again. I think it might be, not sure how relevant this will be generally, but also when you've got people on 0 hour permanent contracts, just thinking also about what, even if that contract isn't terminated and the individual doesn't necessarily do any more work, they're still accruing holiday. So if you say they did some work at the beginning of January, did some work for the whole of January, contract wasn't terminated until December just because everyone's busy and they haven't thought about it, and then one day they've just gone, oh, we need to end that, they will have accrued 5.6 weeks worth of annual leave entitlement. So I think people can be a bit, if you're thinking about it, and if you realistically don't need that contract anymore, to terminate it. So sort of keeping on top of admin when it comes to contracts and things. And even it might not be appropriate, but for schools and things like that as much, but using fixed term contracts where you can, that are terminating automatically. If there is an assignment where it's sort of easier to just stick them on a 0 hours permanent contract, but actually a fixed term contract for that particular role would work, potentially thinking about doing that as well, because that will take off a lot of the burden of having to remember to terminate it.
Yeah.
And it's a lot clearer what entitlements will be in those positions as well.
Yeah, and that's really interesting, because I know from hospitality and retail, there are a lot who do actually then take on as a whole new thing. You know, we think it's just like, I think with this one, you automatically think of things like education and, you know, health and social care, etc., where those contracts are more readily used. But actually in my head now, I'm thinking hospitality and retail use those contracts on a regular basis. And like you said, the admin side of it is probably the side that is not picked up as quickly as potentially it should be, and it could potentially cost you an awful lot of money then, is what we're saying.
Just made me think, I don't think I ever ended my waitressing contract, 0 hours contract, when I was 16. Got loads of annual leave.
That's it. Just give them a quick call.
Just gets missed in these casual roles. So
yeah. Okay, really, thank you. That's really good, and I appreciate we've gone off the subject a little bit, but I think it's all worthwhile. Ro, any other questions that are in that we need to answer, or are we done?
No, I think we've covered off everything. Like I say, if there's anything else, then we can answer them after.
Yeah. Okay. Alrighty. Well, thank you very much, Sean. Thank you very much, Annie. Always a pleasure. I'm sure we will have you back in the shed at some point, especially with the changes to the EU reforms that we're looking at. It's going to be a busy year, I think, in terms of employment law.
Yeah.
So buckle up, guys. We could be in for a bumpy ride again. So yeah, it'd be lovely to see you back. Thank you very much for your time today. Obviously, if people do need to get in contact with you, we can put your details. We'll put your details on the information when we post this out later. But for anybody who is listening on playback, Sean McDonough, Annie Hill, Moses Druitt, offices in Bath,
Wells and
Wells
Sherborne.
And Sherborne. So good coverage in terms of sort of like Southwest. Happy to help you. Potentially they can find you both on LinkedIn, I guess.
Yeah, LinkedIn, mosesdruitt.com as well. So
okay.
yeah, very happy to talk to people. So, and you know, brilliant. Just because there'll be clients of yours, so we just have a general chat to start with. That's absolutely fine.
Great. Okie dokie, brilliant. Okay, well, thank you very much again. Anybody who is interested in obviously progressing the conversation, then please do contact us via our local channels, which most of you know. We have the hello@RowanHR. Our website is rowanhr.com, and our social media on LinkedIn is Rowan Consulting. Please connect with us if you'd like to. Lots of resources available on our website, which I said is rowanhr.com/resources. For those of you who are listening on playback, the links will be shown on the show notes. So go to our website and you'll be able to download them from there. Thank you for joining me. This has been a Shed Talk by Rowan Consulting, HR and organisational design specialists, working with business owners and leaders to structure their business for growth and change. If you've enjoyed this Shed Talk, please feel free to share with your colleagues and contacts. And to subscribe to our videos, click the subscribe link where you're watching this video right now. You can subscribe to our mailing list, as I said. And in the meantime, obviously, stay well, and we will see you very, very soon. Thank you very much.